Greetings to all who have joined us. Welcome to another Avid Readers Forum discussion. Today we're going to be discussing about second generation rights under the Constitution of Kenya 2010. As is tradition at Kabarak Law School, we always start our discussions with a word of prayer. And so at this juncture, I'd like to invite Steve, a 1.1 student who's here with us at Sawia Auditorium here at the law school, to guide us with an opening prayer. Karibu sana, Steve.
Yes, so let us bow our heads for a word of prayer. Dear Heavenly Father, we come before you in prayer this afternoon, O God, thanking you for the gift of life. And Heavenly Father, even as you're attending our Avid Readers Forum, O God, we pray, O Father, that you may open our hearts and our minds, O my Father, to gain something new and take it home at the end of the day. In Jesus' name I do pray, trusting and believing.
Amen. Thank you very much, Steve. To set a bit of context on what this Avid Readers Forum discussion series is about, I'll invite Mr. Cedric Kadima, who's a co-coordinator at Avid Readers Forum, to explain to us what exactly is this second episode about. Mr. Kadima, if you can hear us, you have the floor.
Yes. Thank you very much, Melissa. My name is Kadima Cedric. I'm the co-moderator. Oh, sorry, I'm the co-coordinator at the Avid Readers Forum. And I welcome you all to today's session. Today's session, we're discussing the second generation of rights. And it is by design indeed, because it's a precursor to celebrating Katiba at 15, which will be on 27th of August, 2025. Basically, we are looking at our steps since we promulgated this Constitution of Kenya 2010 and see the progress that we've made, areas of improvement, and basically to come up with recommendations for better implementation of the provisions of the Constitution of Kenya. Last week, we had a discussion on the first generation of rights where we looked at civil and political rights. And this week, we are looking at economic, social, and cultural rights. And we are joined by Senior Counsel Charles Kanjama, who will be the lead discussant in today's conversation. So I welcome you all in this journey. I welcome you all also in the subsequent journey where we'll be discussing the third generation of rights, which will be next week. And also the week after, we'll be discussing the emerging rights, which we'll be calling them the fourth generation of rights. So I welcome you all to these discussions. And I throw back the ball to Melissa for a session to commence. Thank you.
Thank you so much, Kadima. I guess we'll just jump into the discussion. But before that, just to remind our audience that you can find the episode of the first discussion on the first generation rights on our YouTube channels at Kabarak Law School. And also you can join in this discussion on our Twitter handles and LinkedIn, which we're going to put in the chat box in just a few. We are very grateful to all of you joining us from far and wide. My name is Melissa Mungai. I'm a tutorial fellow and research coordinator here at the School of Law, Kabarak, and I'll be your moderator. I'd like to, well, it's a bit tricky to say, introduce our lead discussant because he's known to all of us, especially in the legal fraternity. If I put together a bio, it would take maybe, 20 hours or more to put it together, summarize it, and read it out. So I thought I would just, out of respect, ask our senior counsel to introduce himself to us briefly. And then if there's anything he's left out, we can keep adding more and more to the profile as we go along in this discussion. So Senior Counsel Charles Kanjama, if you can hear me, karibu sana, and you're welcome to introduce yourself and give us a few remarks.
Okay, very well. Good afternoon, ladies and gentlemen. I'm trying to look for where the video is because I can only see audio. Is there meant to be video or is just meant to be audio? Just confirm that to me.
There is supposed to be video.
Yes, I can only see the audio connection. The link that I was sent only has audio. So will we proceed with the audio and I just go ahead, or how do we deal with that?
Yes, absolutely. I think my team will promote you to a panelist, and I think that should be sorted. But we're so happy we could hear your voice, so you can just start up with the introductions. But karibu sana.
Okay, the video has come. Good afternoon once again, ladies and gentlemen. My name is Charles Kanjama. I'm an advocate of the High Court of Kenya. I was admitted in the year 2003. I'm also a senior counsel admitted to the bar of senior counsel in the year 2022 by Uhuru Kenyatta just before the elections of 2022. I ran a law firm called Muma and Kanjama Advocates from the year 2006. So this is 19 years now. And I'm the managing partner. I work as the head of our disputes department. So I've been involved in many court cases, litigation of all kinds, including constitutional cases at all levels of the court. I was also in the past a council member of the Law Society of Kenya between 2012 and 2014. And then for 4 years from 2016, I was the inaugural chair of the Nairobi branch of the Law Society of Kenya. I set up the branch from the ground up. I established several bar bench committees. And one of these was the Constitutional and Human Rights Bar Bench Committee. In addition to that, I've been involved in several constitutional cases in the High Court, Court of Appeal, and Supreme Court, both in my job as an advocate with Muma and Kanjama Advocates and in my role as the chair of LSK Nairobi branch. I also serve as the chair of the Kenya Christian Professionals Forum, which is an organization that brings together Christian professionals from different or diverse professional groups and different Christian organizations in Kenya. And in KCPF, we have several advocacy areas, which include sanctity of life, family values, values-based education, religious freedom, and good governance. I was requested to talk about the subject matter of second-generation human rights. I used to teach law students at Strathmore University several years back. I never taught the topic of human rights, but I've always been interested in it. And so I'm going to give a few initial remarks because I have been involved in seminars and conferences where I have talked on aspects of human rights. And of course, the challenge is that among the students who are listening to me, I think some of speaking, recognizing you are a diverse. But excuse me if I start by going back to some of the basics before I focus on the 15th anniversary of the Constitution of Kenya, 2010. First generation human rights are recognized largely in the 1948 Universal Declaration of Human Rights. That 1948 Universal Declaration of Human Rights is sometimes attributed to Eleanor Roosevelt. She was the wife of President Roosevelt of the United States, of human rights discourse and the natural law perspective in explaining why law exists, why do we have law, what is law, and how should law develop. And you all remember, because you've all at least done basic world history, that the crisis that gave rise to the Universal Declaration of Human Rights is the same crisis that gave rise to the United Nations Charter a few years before, which was the Second World War, and the massive displacement of peoples, the massive destruction of properties, the massive instances of torture and other war crimes, and the millions of deaths that arose because the nations of Europe, joined by a few other countries in the world like Japan and United States, went through a period of 6 years of tremendous human conflict. And so human rights discourse began with the Universal Declaration of Human Rights, the first international document in the modern age focused on human rights at a global level. And this was quickly followed by the 1953 European Charter on Human Rights. The European organizations or countries felt that the 1948 Universal Declaration had not gone far enough because it was merely a declaration. It did not have an enforcement mechanism. So the first generation of human rights, you discussed them last week. And I think one of the things that in the discussion must have been recognized is the fact that it was driven largely by the European nations and the other original state parties of the United Nations Charter. The United Nations Charter had recognized issues of peace, issues of international security. The Universal Declaration of Human Rights recognized human rights like the right to life, freedom from torture, freedom of human dignity, to live with human dignity, fair hearing or right to fair hearing, habeas corpus or the right to be presented in court, freedom of assembly, those kind of rights that are called civil and political rights. In 1966, the nations of the West, under the auspices of the United Nations, felt that the time had come to now enact an effective treaty on the first generation human rights that has enforcement provisions. And so there was a process of discussion and debate that had taken place over months or years, leading to the 1966 International Covenant on Civil and Political Rights. Hence, what we call the first generation rights. At the same time, the nations of, you could call them the East, because after the end of the Second World War, the Iron Curtain fell over Europe and over the world. And the Iron Curtain was this division of nations between the Western Bloc that believed in capitalism and democracy and the nations of the Eastern Bloc that believed in aspects of Marxism or communism, where there was common holding of property, and they had a different approach to governance, different to the liberal democracy of the Western nations. So there was an ideological shift or difference between the nations of the global West and the nations of the global East. The nations of the global West believed that the moment you give people freedom, liberty, they will sort out the other things. And so for them, liberty was like the most important human right. Other rights like the right to life, the right to freedom of property, all those were related to the fact that the individual, given freedom with the least amount of control by the government, can thrive and can seek the best future for themselves. To capture it in the words of the American Declaration of Independence, we believe that all men are created equal, endowed by their creator with certain inalienable rights. Among these are life, liberty, and the pursuit of happiness. So this American Declaration of Independence of 1776 was more or less the ideological framework that led to the development of first generation rights. The nations of the East, on the other hand, they felt that an overemphasis on civil and political rights or liberty ignores an important aspect of human society and human flourishing, which is the aspect that when we come together as a community, we pursue economic rights. If you give me freedom, but I am starving, I will still die of hunger. Maybe I will not die because the government shot me and killed me without free trial, without proper hearing, but I will die of hunger. I will die of something else. If you don't enable me to get education so that I can develop, I will be impoverished. I'll not be able to attain my full potential. So the nations of the East began this debate saying that we need to include other rights, economic, social, and cultural rights. And this debate became so heated that the nations of the world eventually decided to do a second draft, a document referring to human rights. So that in the same 1966, a second document was drafted that became known as the International Covenant on Economic, Social, and Cultural Rights. That document, you should all be looking at it. It is available online. And the rights that are found in this document are the ones that are typically called second generation rights. In the Constitution of Kenya, 2010, these second generation rights appear. They don't appear as effectively in the Constitution of Kenya of 1963 for the simple reason that the 1966 International Covenant on Economic, Social, and Cultural Rights had not yet been drafted and developed and approved. It appeared after we entered into our independence constitution of 1963. And when in 1969, our independence constitution was reorganized or rearranged, we repealed some provisions, we changed the order of certain chapters. The chapter on human rights, which used to be chapter 2, was taken to chapter 5 from section 70 to, I think, 87, and so on. We did not really include new provisions. We were just removing some and rearranging the order of the Constitution. So this act of 1969, which was a reformulation of the Independence Constitution, did not introduce the second generation rights. So largely, the Constitution of Kenya of 1963 that governed us until 2010 focused on the first generation rights, which are the civil and political rights. And now in 2010, because there was already more than 40 years of jurisprudence, of academic discussion, of legal developments regarding second generation rights, it was felt that we need to include these second generation rights. Some of these second generation rights appear in the African Charter on Human and People's Rights, because the African Charter on Human and People's Rights was agreed in the year 1981. So that is like 15 years after the International Covenant on Economic, Social, and Cultural Rights. Incidentally, after the United Nations agreed on the text of these two covenants, the one on civil and political rights, which are the first generation, and the one on economic, social, and cultural rights, it took a number of years before these two documents were ratified, because several countries focused on signing and not ratifying some of the covenant. The countries in the West, they focused on the ICCPR. The countries in the East, they were happy to sign both of them. Eventually, both of them came into force. And by the time we were doing the African Charter on Human and People's Rights, it was clear that the economic, social, and cultural rights had gained global acceptance. And so they also appear in the African Charter on Human and People's Rights. Incidentally, I want to say 2 or 3 things before I come to now focus on the second generation rights. By 1966, the nations of Africa, of the African continent, several of them had gained independence, including Kenya. So the nations of Africa were not in existence, most of them as independent nations, in 1948, when the Universal Declaration of Human Rights was being drafted. They were not members of the United Nations. They were not signatories of the United Nations Charter. As they gradually became independent, they became signatories of the United Nations Charter. When the nations of the East and the West were debating first and second generation rights, the Africans had already, in theory, together with several countries in Latin America, become part of the non-aligned movement. And the non-aligned movement had more than, I think, 70 member states that said, we understand there is an iron curtain. There's a Cold War between the East and the West. The West is pushing civil political rights. The East is pushing economic, social, and cultural rights. We, as a non-aligned movement, embrace and appreciate both kinds of rights. We recognize the importance of individual liberty. We also recognize the the importance of human flourishing, which is economic, social, and cultural rights. The nations of Africa, which were part of this non-aligned movement, they made one important contribution in 1966 in the debate between first and second generation rights. And their contribution can be found in Article 1 of ICCPR, which is identical with Article 1 of ICESCR. Sorry for using those initials. These are the International Covenant on Civil Political Rights and the one on Economic, Social, and Cultural Rights, the two 1966 human rights treaties. Interestingly, they have the same identical Article 1 because the nations of Africa said, we have fought colonialism and now we are fighting neo-colonialism. Please put in your different treaties. That time it was not yet completely clear that both treaties will have the force of law. Put in each treaty the right of self-determination. And so Article 1 of both ICCPR and ICESCR talks about all peoples have the right of self-determination. By virtue of that right, they freely determine their political status. So it is making reference to first generation rights, and freely pursue their economic, social, and cultural development, making reference to second generation rights. So the nations of Africa are saying this may be individual human rights, but there's also an element of group rights, the right of self-determination, all peoples together, the peoples of Kenya, the peoples of Uganda, the people of Morocco, the people of each country, sovereign nation, have the right of self-determination. And that this group right embraces both first and second generation rights. Hence, we find that in 1981, when the African Charter is coming into force, the nations of Africa are already a bit unhappy with the exclusive insistence that human rights are just individual. And so, unlike all the other continental human rights treaties, when they entered into their treaty in 1981, they put together individual human rights as well as people's rights. And that is why their treaty is called the African Charter on Human and People's Rights. So this right of self-determination gives rise eventually to the third and fourth generation rights, which you will discuss in subsequent sessions. Having said that, let us now focus on these second generation rights: economic, social, and cultural. The idea is that the human person, as an individual and also as part of a group or as part of a community or society, is entitled to pursue and achieve flourishing of an economic kind, social, which means in their interactions with others, and cultural, which means preserving the legacy and history of their community and their peoples. That is economic, social, and cultural development. One of the key, you could call it fundamental differences between first and second generation rights is that in the case of civil and political rights, as the Western nations were saying, those rights, you enjoy them immediately and fully. You enjoy them right now and you enjoy them 100%. So the nations of the West were saying true human rights are rights which you can almost say are measurable. When you talk about the right to life, I enjoy life right now. You don't take away my life. It's not incremental, it's complete. So the rights are enjoyed completely from the beginning. And they were saying, how can you have rights? How can you ask state parties to guarantee rights that are incremental? Because right to food, how do you get right to food unless you gradually keep improving food production? How do you get right to education unless you gradually improve your education systems? So it became recognized that the second generation of rights requires a paradigm shift because they are not immediate and full. They are gradual, they are incremental. And that is why in the Constitution of Kenya 2010, we have a very interesting provision because now the drafters of the Kenyan Constitution, after one generation, more than 30 years of experience with the academic discourse and the legal developments on second generation rights, were able to recognize that these rights are incremental. And that is why you will notice that there are provisions on the incremental nature of human rights that appear in the Katiba of 2010. When you look at Article 43, which is the article that deals with economic and social rights, it doesn't deal with cultural rights. Those ones appear in Article 44. It says every person has the right to the highest attainable standard, so that it is something that is gradual and incremental. And when you look at Article 20 on application of the Bill of Rights, Article 20, paragraph 5, it says, in applying any right under Article 43, if the state claims that it does not have the resources to implement the right, the court shall be guided by the following principles. And then the principles have been explained. That the state must show that the resources are not available. It must allocate resources by giving priority to ensure the widest possible enjoyment of the right of fundamental freedom. So it is a question of resource allocation, and it is a question of incremental development. That is what Article 20 read together with Article 43 provide. So this is a new philosophical approach, and it is an approach that is complementary to the approach on the civil and political rights, which is about immediate and full enjoyment from the very beginning. When we come to Kenyan jurisprudence, because of course there are economic, social, and cultural rights. Before I come to the Kenyan jurisprudence, I will tell you which are the provisions in our Katiba that are dealing with second generation rights. You have Article 41 on labor relations, trade union activity. That is a second generation right. You have Article 43 on economic and social rights, Article 44 on language and culture, Article 45 on the family. These are second generation rights. It is true that the family appears in ICCPR as a first generation right when you talk about it from the perspective of the right of marriage, but there are aspects of family values that can fit within social and cultural rights. These are examples of second generation rights. And I honestly think that also Article 46 on consumer rights is a second generation right. So what is the approach that the court in Kenya has adopted in dealing with first and second generation rights? I'm just going to mention one case before we go into the Q&A, and then I finish my introductory remarks. And this is the landmark Supreme Court judgment in Mitu Bell Welfare Society versus Kenya Airports Authority. Mitu Bell, we call it Mitu Bell. And this case was dealing with second generation rights. And there are two important things that this decision brings out. There are many others, but I want to focus on two. One of them is that the court is able to embrace international law, including also comments of UN organizations like the UN guidelines on evictions to implement practical approaches to resource allocation and procedural safeguards to ensure that resources are incrementally allocated to those who suffer lack of housing, lack of food, lack of education, etc. That is one of the things that the Mitu Bell case does. It recognizes that you need to have procedural guidelines that will guide state organs when they're allocating resources to secure these second generation rights. The second important development from Mitu Bell is this. Because first generation rights are immediate, when a court gives a determination on first generation rights, it becomes functus officio. It can quickly say that you should pay the plaintiff 10 million shillings, that the compensation to be given to this other party is so much. It can give a declaration of violation of rights and immediately craft the remedy, which is compensation or specific performance of a particular concrete action. But in the case of second generation rights, sometimes the implementation is also incremental. It requires several different and disparate voices to be heard in the process of crafting a remedy. So in the Mitu Bell decision, the Supreme Court upheld the idea of structural interdict, which is an amazing development in Kenyan jurisprudence. Structural interdict is not something that was invented by Kenyan courts. It has been recognized in South Africa and in some other countries. Structural interdict basically means that the court is no longer functus officio after giving the judgment. and the judgment being converted into a decree. Because under the general principle of procedural law, when the judgment is given by the court can only get involved in enforcement, that is execution of the specific concrete orders issued in the judgment, or you can seek to review the decision or you appeal. But in the case of structural interdict, the court can actually give broad orders and then oversee the process of enforcement. An example is the court can say that these people are lacking housing. We want the government to come up with a policy to provide housing for the people who are evicted in this or that other place. And in 6 months from today, you will give us your policy on housing, and that policy should ensure that these people who are lacking housing are given affordable housing within a certain period of time. This is just an example. So structural interdict expands the power of the court to oversee the incremental realization of second generation rights. So clearly, now that structural interdict has been recognized as a legitimate remedy by Kenyan courts, despite the fact that it is not expressly stated in Article 23 of the Constitution, it has created the avenue for future, more effective litigation on matters of second generation rights, and also for these rights to stop being treated as just things for the future that you don't need to enforce to a certain extent today. Martin Luther King in 1963 led what is called the March to Washington in the United States of America. And he gave one of the famous speeches that you can come across during that March on Washington. And one of the things he said is, we are tired of being told that we cannot get segregation completed or abolished today. We are tired of being given a prescription of the tranquilizing drug of gradualism. So a prescription whereby the drug is called gradualism. You can't get it today, just wait. We'll come back to it, we'll revisit 1 or 2 years down the line, which is the danger if the court is only able to give a remedy that is accessible today and has nothing more to say about the matter. So basically, the structural interdict allows the court to give a remedy that can be implemented over a period of, say, 6 months to 2 years, and that can result in concrete benefits to the parties who appear before the court. Let me say that as lawyers, we might assume that rights can only be enjoyed when you take the case to court. But the idea of the remedy of structural interdict is that it also sensitizes Parliament, as well as the executive, the other arms of government, to become more aggressive and more conscious about the need to incrementally allocate resources and implement policies that will secure real enjoyment of second generation rights. Thank you. So those are my initial remarks.
Yes, and really they do set the stage. Thank you so much, Senior Counsel. I should confess here that I was your student at Strathmore. You taught me criminal law, and I'm so happy to, the articulation, the clarity, the humor, it's still intact. So thank you so much for taking me back to the classroom. In fact, for me, it's strange to call you senior counsel. In my mind, it's always Mwalimu, but we'll oscillate in this discussion. Of course, now we want you to speak a bit more about 15 years on, but I'm just using my discretion as moderator to just, as you think about the, 15 years on, these questions on second generation rights, the ideological shift is interesting. The reforms in litigation and thinking about socioeconomic rights is interesting. But these are just bread and butter issues at the end of the day. And I don't know what you think about that. Because when I think of socioeconomic rights, I think of survival. As you said, you need to eat, but how much food will you eat? We need clean water, we need healthcare, we need education. These are bread and butter issues, daily concerns. Sometimes we can think of these bigger picture questions, as you've rightfully put them, in the historical development of socioeconomic rights. But really, why is it so difficult to just secure a people's survival? That is what my bane of contention usually is with socioeconomic rights. But as of course we discussed the 15 years on transition, I'm sure some of these questions will be answered. I want to remind the audience, both here at Sawia Auditorium and online, that we have the chat function. Please prepare to ask your questions because we're just about to jump into plenary. So, Senior Counsel stroke Mwalimu, as you know, we are reflecting about Katiba at 15 this year. What do you think, if you were to take stock, you've rightfully mentioned like the Me Too Bell decision, that was one of those monumental decisions that we cannot forget. But what else do you think in this 15 years time span should be something that people can consider and reflect on from your perspective, of course, in the many hats that you wear? Karibu with your reflections.
Okay, thank you so much for those comments and for the questions that you've asked. The first thing that comes to mind is that unlike civil and political rights, in which each signatory or member state of the United Nations exercising its sovereignty has an ability to attain largely with its own internal processes, because you can ensure that right to fair hearing, freedom of assembly, all those things, you can implement them internally. In the case of second generation rights, there is need for much more solidarity between the member states of the United Nations. Because to attain a highest attainable standard of healthcare, to get housing, to get sufficient food, we are in an interconnected world where there is need for trade, for relationships, for aid, for vulnerable populations. So it is something that requires much more interaction between the member states of the United Nations, between the countries of each region, whether it is the African Union, the European Union, and so forth. And so the fact that there needs to be more collaboration probably is an issue that has contributed to the low rate of attainment of second generation rights. Right now, we are seeing that there are many fractures to global solidarity. We have trade wars. We have tariff wars. Of course, we had the World Trade Organization that was meant to create a level playing field in the area of trade. We have regimes like on intellectual property that may continue a situation in which the first world continues to dominate access to resources. They continue to be much better off in terms of the GDP per capita or Human Development Index, the important measures of development, while the nations in the global south are not growing fast enough. It's almost as if as the nations of the global south are growing, the nations of the first world are growing even faster. So the gap is increasing. Of course, we have had successes like the case of South Korea, the case of Japan. China is increasingly a success in the way they've been able to lift hundreds of millions of people out of poverty. And then there's also the second issue. There's an interconnection between the ability to attain second generation human rights and issues of good governance and leadership and the fight against corruption. And so we are finding that in the case of second generation rights, the nations of Africa are struggling partly because of external factors, the global environment, but partly because of self-inflicted wounds relating to bad governance, bad politics, corruption, and so on. And these are issues that are therefore interfering with the ability to attain second generation rights. And they are slowing down our ability to reach our ultimate potential. Having said that, if we look at Kenya in 2010 and Kenya in 2025, the emphasis on public participation, the structural reforms in our governance structure with constitutional commissions, with the national government and the devolved government, they are accelerating the process of awareness and attainment of these second generation rights. So for example, because of devolution, you have many more people in the countryside in Kenya or in the different counties in Kenya where health facilities are now closer because counties are focusing on developing health facilities, third, fourth, and fifth. They have different measures of the quality of the and facilities of the health facilities. So they are developing them. You find that there are more doctors and nurses in the hospitals in the counties. If we talk about a question of clean and safe water, there are several counties that are developing water transportation or water translation facilities and drainage to ensure that more people have access to clean water. If we think about education, education is largely a national government function, but there has been an improvement in the number of people in this country who are getting to high school, getting to technical colleges and universities. So there has been growth. And the fact that both the county government and the national government, when it is decentralized through the Ngao and the other government agencies to the counties and the wards or the sub-counties, are focusing on second generation rights means that there is continued improvement in human development. And I think the concrete indicator of this is that the United Nations Human Development Index, the one of UNDP, now ranks Kenya as a middle income country on the lower part of the middle income scale. And 15 years ago, Kenya was a low income country. And that means that clearly there are even concrete indicators of advancing human development in Kenya.
Thank you so much. Yeah, I actually agree on the public participation part being connected with decentralization, because power has been demystified a lot. Everybody is having a conversation on their entitlements, and it's also good to see even digitally. So I like that point on middle income. I also like the response to my question where you brought up the issue of the market, that we should never underestimate those neoliberal conversations, and indeed the need for interaction and solidarity. I agree. And leadership and governance as well. Yes, if people are inclined to be more ethical and less greedy, then some of these things will be priorities. I thank you for those particular points that we must think about as we reflect about Katiba 15 with regard to second generation rights. And Senior Counsel Mwalimu, there are some questions already coming up, and I like the first because it's on this ideological shift question. This question is from Elvis Mogesa Ongiri, who's going to be a final year student at Kabarak Law School very soon, and many other things. But he introduces himself, if you can see it there. He's editor-in-chief of Kabarak Law Review, and he's also an editor in this upcoming Katiba 15 book project, which we must involve you without fear or favor. Anyway, but he asks, do you think that this terminology, generation of rights, I struggle with it as well. You know, what are these generations? But you've explained it well. Does it perpetuate the idea that there is a hierarchy among these types of rights? Secondly, is this terminology present in the preparatory works of the UDHR and even consequently the ICSCR and the African Charter, or is it merely an academic creation, possibly by the West, that would affirm a hierarchy? If it is, after all, an academic creation to affirm a hierarchy, I would suggest that we should dissuade from such terminology. I think Kenyans would call it kizungu mingi, which is too much English. I have a question here by a guest who asks, okay, I don't know whether it's he or she, but they ask, I am kindly requesting to get your thoughts specifically on paragraph 132 of the Mitubel decision. That is so specific. The Supreme Court started well by acknowledging the application of international law, including general comments. But when they got to paragraph 132, they established a hierarchy that has always troubled me, ranking international law below the Constitution, legislations, and municipal cases. I am trying to foresee a circumstance where we might have a conflict between international law and a municipal legislation, specifically in relation to second generation rights. And in that instance, you find international law more transformative than the legislation. Will we kick out the transformative international law provisions simply because of the black letter of paragraph 132 of Mitubel? This applies especially to the right of housing and food. Thank you for those two questions. I think, Senior Counsel, you can go on with those. And then I'd like us to pan out to the audience here with me physically. They are first-year students, and I think they have lots of questions and comments. So you can start with those two.
Okay, thank you very much. I'll start with the questions by Elvis Mogesa. His first question is the terminology on generation of rights. I think I tried to explain at the outset how the different kinds of rights developed and how there was this debate between the civil and political rights group and the economic, social, and cultural rights group. And the fact that the civil and political rights were first recognized in the modern age at a global level in 1940. So in the 1970s, after these two covenants, international covenants, had been adopted by the United Nations, going ratification, there's a character called Karel Vasek, who's the one who first promoted this idea of different generations of rights. And the first generation of rights was neatly connected to ICCPR. And the second generation of right was neatly connected to ESCR, the economic, social, and cultural rights. And then he also proposed a third generation that relates to collective well-being and solidarity, a right to environment, development, and peace, which you could say some of them appear in the UN Charter of 1946, 1945. Some of them appear in the African Charter on Human and People's Rights when it's talking about group rights. And some of them appear in Article 1 of ICCPR and ESCR. So the question is, this is just an academic approach or rule of thumb for purpose of elaborating on all these kinds of rights. Does it perpetuate the idea that there is a hierarchy among this type of rights? My answer is that it may perpetuate that idea. And there is a group who believes in the universality and indivisibility of human rights. That is a contemporary concept that is largely upheld by human rights scholars. But personally, I'm one of those who still insists that even though human rights may be indivisible and universal, there is a hierarchy. And I am a strong proponent of the idea that any aspect of our physical reality as human beings involves hierarchy, whether it is in plants, plant kingdom, animal kingdom, even in human beings. Whenever we come to organizations, we choose leaders. For anything to be effective, there is a hierarchy. Even in the human body, there are some organs that are more important than others. You lose your heart, you stop breathing, you are dead. But your heart can be, you can get someone else to give you a heart. You can get a new heart through a transplant. But if you lose your brain, that's it. So I believe that indivisibility of human rights doesn't mean that we ignore the fact that there's a hierarchy. Some rights are more important than others. Even among civil and political rights, I believe there's a hierarchy. When you look at most of these human rights treaties and human rights charters, including the Constitution of Kenya, you find the right to life appears always before other rights. Because if you are dead, you can't enjoy any other right. It's so basic and fundamental. So I don't think there is really a problem with hierarchy of rights. I know that not many scholars talk about hierarchy of rights. I think we just need to find how to harmonize the concept of hierarchy with the concept of indivisibility. If I may use a Christian analogy, St. Paul in one of the letters, the Corinthians, says there are many organs of the body. Each organ has a different function, but they function as indivisibility, recognizing hierarchy. So unity and hierarchy are okay. They can go together. But I do agree that this concept of 3 generations gives the impression that first generation rights are more important than second or third generation rights. And I think all generations of rights are important, but it would be an abrogation of academic rigor to assume or to hold that there is no, you cannot weigh one right as against another and find either a priority or higher significance to one right than to another. The second question you've asked is whether the terminology about generation of rights is present in the preparatory works of the human rights treaties of the 40s and 50s and 60s? And the answer is that it is not evidently present. What is present is this debate about whether the rights are real or not real, validity. And the question of generation appears in the 1970s. So it appears after the rights have become recognized as an academic approach to try and explain why the rights developed along 2 or 3 different paths. So you suggest that we should dissuade from such terminology. And I think that is an issue that is open for further discussion or debate. Personally, I don't have any problem with the generational discussion about human rights, because I think it aligns to the historical development of recognizing these rights. The second question was about paragraph 132 of the Mitubel decision. I have paragraph 132 of Mitubel, and I don't know whether I'm able to share on the screen, but I will just explain to you for those who are listening. Paragraph 132 of Mitubel is where the Supreme Court said that Article 2.5 and Article 2.6 of the Constitution, which are in the article that deals with source of law in Kenya, are inward looking. It requires Kenyan courts of law to apply international law, both customary and treaty law, in resolving disputes before them, so long as the same are relevant and not in conflict with the Constitution, local statutes, or a final judicial pronouncement. There had been a lot of debate before Mitubel on whether Kenya, under the new Constitution, which is now 15 years old, was a monist state or a dualist state in international law. And for first and second year law students, of course, these terms are strange to you. You will cover them when you deal with international law. Countries in the world can either adopt a dualist approach where they separate international law and domestic law. So when they enter into treaties or when their countries are bound by international law, that law is valid at the international arena, but is not valid at the domestic arena until it is domesticated. The treaties are ratified and then they're domesticated through local statutes. And in monist countries, the moment a country becomes bound by international law, maybe by ratifying a treaty, without any further act of domestication, that international law becomes applicable even in the local courts. So the Supreme Court, in Article 132, was dealing a bit with this question and with the related question of hierarchy of laws that appears in Article 2 of the Constitution and in jurisprudence. Because we know that the Constitution is superior to acts of parliament. So Constitution is the most important. Fundamental is the Grundnorm, according to Hans Kelsen. Then you have statutes, acts of parliament. Under Article 94 of the Constitution, only parliament has the power to establish law that has a force in the country. And then you have subsidiary legislation. Parliament can give its power, can delegate part of its power to other organs to establish law. And then you have jurisprudence, which is decisions of the courts that can enter into gaps in the law, and so on. So the Supreme Court said under paragraph 132 of Mitubel that international law cannot be superior to the Constitution of Kenya or even to local statutes. In the hierarchy of laws, international law can be used where there is a gap in the local law to clarify. But it cannot supersede. It cannot be used to amend or repeal or overrule the Constitution, or even to overrule an act of parliament which has been enacted in a manner that is consistent with the Constitution. So the question that is being asked is whether this paragraph 132 is causing a problem by the way it establishes a hierarchy where international law comes below the Constitution, legislation, and even decisions of the local courts. My own view, when Mitubel judgment was issued by the Supreme Court, I was actually smiling. I'm in a group of academics and some senior lawyers where we discuss some of these scholarly issues. And some of my colleagues, they like the idea of Kenya being monist or international law being superior to the Constitution. And when I used to teach legal systems and subsequently, I've always thought that it would not make sense because it would be an attack on the sovereignty of any nation, at least for our African nations, for us to give the international arena the power to overrule our own sovereign laws. Also because the true dynamics of the international legal arena is that the countries of the first world tend to have and exercise more power in the process of lawmaking. So if international law was to become superior to the Constitution, it would actually go against Article 1 of International Covenant on Civil and Political Rights and Article 1 of the International Covenant on Economic, Social, and Cultural Rights, and against the African Charter on Human and People's Rights, which all emphasize the right of self-determination. So I think that for me, paragraph 132 of Mitubel is actually very well drafted. I like that particular paragraph myself, and I support it. And then the last question that has been asked related to Mitubel is whether this interpretation in paragraph 132 is going to take away the progress with the second generation rights because of kicking out transformative provisions about international law. I think that even though international law has been demoted a bit in the domestic hierarchy of laws, the Supreme Court in this Mitubel case, as well as many other cases, has continued quoting international law as well as decisions of foreign courts and foreign jurisdictions, but always with a caveat that you cannot just pick and choose decisions from other legal forums and apply them in Kenya without discerning the circumstances of the people of Kenya or their constitutional text. So I think that it is still quite possible for us to continue the journey of transformation that was triggered by the Constitution of 2010, despite or even because of what the Supreme Court recognized in paragraph 132 about the place of international law in the domestic legal sphere.
Thank you, Senior Counsel. Is there anyone in the room who has a question so we can diversify the outlook? Or a comment? Okay. As they're thinking, I think you're giving them golden nuggets that are so powerful, they become overpowered. Anyway, there is a question by Favor. She should be, I think, going to second year now here at Kabarak Law School. She's asking, is the progressive realization principle being used by the Kenyan government as a loophole to delay implementing economic and social rights indefinitely? I think you've answered a bit of it even in your last question, but let's see how that goes. And then Karaoke Joan Juguna, I believe also going second year, is asking, In your introductory remarks, you mentioned Article 25, explaining the incremental and gradual nature of Article 43 rights. Is resource limitation a genuine justification or a convenient excuse? In a country where billions are lost to corruption annually, can the state credibly argue that economic constraints are the reason economic and social rights remain unmet? Over to you.
Okay, thank you for those questions. Both of them are touching on the question of progressive realization. So as I answer them, allow me to also make reference to Article 21 of the Constitution. Article 21 is titled Implementation of Rights and Fundamental Freedoms. And it says that it is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. So there are 5 verbs that are used in Article 21. Observe, respect, protect, promote, and fulfill. So observation has to do with the current situation. What is there? The right that I have as at now, can you observe it? Can you respect it? Which means don't just observe, but also respect, like uphold it. Can you protect it? Can you help me? Can you defend me in my enjoyment of that right? And then there is a promote, which is now an action of growth, incremental realization, and fulfill. And then Article 21, paragraph 2, now uses the words progressive realization. It says that the state shall take legislative, policy, and other measures. So legislative measures, those are taken through parliament, the second arm of government. Policy measures, which are taken by the executive, the first arm of government, if I may say. And then other measures, whatever other measures are available, administrative, whatever kind of measures are there, including the setting of standards. You see, to set standards means to say, for example, we want every Kenyan to have a house that is permanent, or we want not to have any homeless Kenyans roaming in our streets. You have to set standards to achieve the progressive realization of the rights guaranteed under Article 43. Article 21 also recognizes that apart from achieving these second generation rights progressively for the global population, that we have special needs. We have vulnerable groups that require a special focus. And these vulnerable groups appear in Chapter 4 of the Constitution, Part 3, that is from Article 53 to Article 57. Children, persons with disability, youth, minorities and marginalized groups, older members of society. And then Article 100, of course, also mentions women, as well as Article 21, paragraph 3. So the state is meant to do affirmative action. Apart from progressive realization, also affirmative action for the vulnerable groups. And then Article 21, paragraph 4 says the state shall enact and implement legislation to fulfill its international obligations in respect of human rights and fundamental freedoms, which means they need to domesticate their international obligations on human rights. So with that background, the question by favor about whether progressive realization is a loophole to delay implementing economic and social rights indefinitely is, it can be. And it is up to Kenyan citizens, including lawyers, to hold the government to account. I'll also say something else. Article 43 of the Constitution refers to second generation rights using both vertical and horizontal human rights language. On the other hand, Article 21 of the Constitution, Article 21, refers to economic, social, and cultural rights using only vertical human rights language. So it's important to note that the historical approach to human rights at the international sphere was to hold the government responsible to secure the human rights of the citizen. So the citizen was the beneficiary and the government was the principal or the trustee or custodian of human rights. But the horizontal approach to human rights recognizes that human rights can be violated by other citizens or other human beings. So that it's not only the state to secure human rights of the citizen, but citizens also should secure human rights of their fellow citizens. So in answering the question about progressive realization of human rights, let's also recognize that we also should assist in the course of our work, economic development, help our employees, our co-workers, our customers, etc., to achieve their economic, social, and cultural rights. So to facilitate this one, the government can use legislative and policy measures. So for example, the Employment Act says that employees are entitled to maternity leave, paternity leave, annual leave of 21 working days. So the state has given the job now to employers. So in the vertical approach, it is also facilitating the horizontal approach. So the answer to the question of whether it could be a loophole is yes, it can, but it's up to us as the people, not only to insist on the government doing its job, but also to engage in the horizontal application of human rights amongst one another. The question of karaoke was about where corruption and its impact on resource limitation. Is resource limitation a genuine justification? My answer again is that it could be. Kenya cannot provide economic, social, and cultural rights equivalent to Sweden or Norway or the United States of America or the United Kingdom, because our economy is much smaller. So if somebody goes to court and they want to see a highway in Kenya that is of the same quality as the best highways in Europe, or a bullet train in Kenya that is like the bullet train in Japan, then the court will say this is impractical. So that would be genuine. But if the Kenyan government fails to provide basic access to health or education or water, and then they blame lack of resources, then that will not be a genuine justification. So again, it depends on a case-by-case basis, whether each case of denial of economic, social, cultural rights is justified or not.
More are coming in. You've been asked, in your view, do you think that the social, economic, and cultural rights enshrined in the Constitution are exhaustive? If no, what are your recommendations? And I even wanted to add, but it could be a commentary, that I found it interesting that you added Article 44 on language and culture and even consumer rights. That was an interesting perspective, as well as family values in Article 45, which, if time allows, I'll ask my question along those lines. Beth Mwangi is asking you, would you provide any other reliefs and enforcement mechanisms other than structural interdicts that you might have come across after undertaking comparative jurisprudence? Over to you.
Okay, very well. So anonymous attendee has asked whether these socio-economic and cultural rights enshrined in the Constitution are exhaustive. The answer is no, they cannot be exhaustive. And the Constitution itself recognizes that there may be additional rights in addition to the ones that have been limited. These are the constitutional rights that have been expressly stated, but there could be additional rights. Article 19 of the Constitution of Kenya, paragraph 3B, says that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms that are not in the Bill of Rights, but are recognized or conferred by law, right? But are or so there seems to be an echo. What I'm trying to say, I don't know, can the echo be dealt with? Okay, what I'm trying to say is that apart from the economic, social, and cultural rights indicated in the Constitution, acts of parliament can identify additional rights. So for example, under the Land Act, the process of eviction has to follow a certain procedure. So that you could say facilitates enjoyment of the right to housing. That is like a statutory right aligned to economic, social, and cultural rights. I also am a champion for family values. Family comes under social rights. So family is entitled to recognition and protection by the state. But what are these family values? What is harming families? And how can they be protected by the state? So what results in breakdown of families, in disharmony in families? How can they be protected? You might even find in the Income Tax Act, there are some provisions that are helping family solidarity. So that is why I would say that these rights are found in so many statutes, but the anchor is the rights in the Constitution. Beth asked whether there are other reliefs and enforcement mechanisms other than structural interdicts in comparative jurisprudence. I would like to give a caution as I answer this question. Because we are lawyers and our ordinary playing field is the courts, we might overemphasize reliefs that come from the judiciary. And the reliefs that come from the judiciary are found in the Constitution, Article 23. It mentions declaration of rights, injunction, conservatory order, declaration of invalidity of law, order for compensation, and order of judicial review. These are extremely broad. So the structural interdict is a way of having specific performance that involves policy, law, and other administrative actions. But there are other reliefs that may not come from the judiciary, but may come from other mechanisms. For example, in the European Union, in addition to the reliefs or enforcement mechanisms in each country, the European Union has its organs, including the Council of Ministers, the European Parliament, the European Court of Justice, that also can provide mechanisms that help economic, social, and cultural rights be attained. So even in Kenya, apart from the courts, you can have mechanisms that originate from the legislature or the executive in regard to enforcement of human rights. But when you now go to the court, I have not encountered any other distinct enforcement mechanism apart from the ones that I have mentioned in Article 23, plus the structural interdict.
Thank you so much. I like how the questions have also fed into each other. Let me just inform our audience that if you have last minute questions, this is your chance, because we can take a hot burning one here on the chat as we conclude. So I'll give another chance. Anyone with a burning comment, feeling the spirit? Okay. Tough crowd. Yeah, I'm facing a tough crowd. The final question before I bring in our organizer of this event to give some vote of thanks and to make his concluding remarks about this event. Griffins Gero is thanking you for an insightful and educative session. I think everyone here has enjoyed, including myself. I cannot wait to rewatch this and now reflect even better. What's your take on the recent judgment on granting equal capabilities of Muslim children born out of wedlock to inherit property with regards to cultural rights, Article 44 of the Constitution of Kenya? Yeah, I think we can talk about culture. So we've spoken about social economics. So thank you, Griffins, for this question on culture. And also it intersects with my question, which was going to be on family values, but I think you've touched on it. I know that you have sat in leadership positions, that you think about the future of the family. And I usually think if it's the basic unit of society, then this is where charity begins. This is where we think about one another, solidarity and things like that. So if in any way Griffin's question could also answer mine on family values, I would be most grateful. Over to you, Senior Counsel.
Okay, very well. So I am excited about the question of family values. And as I begin answering these two questions, allow me to make a reference to a development that has appeared in business circles, which is what is called ESG reporting. ESG refers to environmental, social, and governance reporting. Because in the old days, it was understood that private corporations, businesses, would focus on one issue, one principal issue, which was profit. It was called the bottom line, either gross profit or net profit. And in the 1970s and 1980s, beginning in academia, the discussion and debate developed is this the only thing that companies should focus on? Eventually, out of this dialogue and debate, the concept of the triple bottom line came up, that all of us, to sustain our development, the concept of sustainability, we need to focus on 3 Ps instead of 1 P. And this was people, profit, and planet. So people relates to the social aspect of human development, profit to the economic or financial aspect, and then planet, of course, environment. And environment requires good governance. And this has given rise to ESG reporting, whereby corporations are now being asked to do sustainability reporting that is not just about profit, but also about the impact of their operations on environment, social, and governance. I attended a recent training. It was a 5-day training on ESG reporting and the various guidelines that have come up on ESG reporting. And I was surprised that when we were discussing the elements of social reporting, there was no mention of family. And yet my organization, Kenya Christian Professionals Forum, is very keen about promoting family values, including the natural family. And I felt that this is a gap at the level of contemporary focus on ESG and issues of social, that we are not recognizing the family as a basic and fundamental group unit of society, that when you come from a family with, for example, both parents, you are likely to have, at least on a sociological perspective, there are higher possibilities of better outcomes, education-wise, health-wise, relationship-wise in future, and so on. So I thought this is a gap that is there in the contemporary thinking on ESG. And so when we talk about second generation rights, you find that it is only in the African Charter on Human and People's Rights where, for example, both dimensions of parental rights and parental duties, as well as children's rights and children's duties, are found. In some of the more liberal human rights treaties, sorry, there's an echo coming back again. Children are only right bearers. They never are duty bearers. They don't have duties to their parents or to their family. Our Children's Act used to provide duties for children and rights as well to contribute to the solidarity or well-being of the family. You see, maybe to obey their parents, and parents had the right to instill their cultural values on their children. So some of these things may not be found in other human rights instruments, like say the European Charter on Human Rights, or even ICCPR and ICESCR. So definitely family is important, and it has a role under economic, social, and cultural rights. And it's a ripe area for greater discussion, dialogue, and inclusion into human rights language. And this, of course, then connects with the question of culture and Islamic culture and Islamic law regarding inheritance. Whenever we talk about culture, one of the issues that comes up is that culture is necessarily different and sometimes inconsistent from place to place. So depending on where you come from, which religion you belong to, your history, you may be part of different cultures that may be inconsistent with each other. And sometimes culture can become an excuse for violation of human rights. And sometimes culture can become a defense against imperialism or neocolonialism. So culture can be both positive and negative. And that is why the right of self-determination includes the aspect of allowing people to enjoy their culture, but only to the extent that it is not inconsistent with the express human rights principles. So you'll find in Article 159 of the Constitution, for example, paragraph 3, it says that traditional dispute resolution mechanisms, these are the ones that come from culture, shall not be used in a way that contravenes the Bill of Rights. So culture cannot contravene the Bill of Rights or be repugnant to justice and morality, or result in outcomes that are repugnant to justice and morality. So for culture, there is a test, which is the test of, are they consistent with justice and morality? Sometimes it's called the repugnancy clause. And so even when you look at Article 44 of the Constitution, as well as Article 11, because Article 11 also talks about culture, it says in paragraph 3 of Article 44, a person shall not compel another person to perform, observe, or undergo any cultural practice or rite. Article 45 on family rights says Parliament shall enact legislation that recognizes any system of personal and family law to the extent that such marriages or systems of law are consistent with the Constitution. So you'll notice that all the clauses that deal with culture put a caveat that they will be limited if they are not consistent with the Constitution. When you look at Article 24, the one on limitation of rights, paragraph 4, it says, the provisions of this chapter on equality shall be qualified to the extent strictly necessary for application of Muslim law before the Qadhi's courts to persons who profess the Muslim religion. So it says to the extent strictly necessary. So when you look at the various provisions, the Constitution recognizes that there are some times when it will limit application of Islamic law, or indeed the law of any other culture, any other cultural right or practice. For example, female genital mutilation was part of traditional cultural rights, has been limited. So the answer to the question of whether the Supreme Court was wrong or right in varying Islamic law to allow children born out of wedlock to inherit from their parents, it is a question of balance between ensuring that children who are not responsible for the actions of their parents do not suffer their parents from the fact that their parents were not married, as well as recognizing that Islamic law has its reasons for having certain arrangements relating to succession or inheritance. So for me, I think the Supreme Court had to balance this. It was difficult for them to decide one way or the other. And the decision they reached is consistent with other decisions in Kenyan courts that in matters relating to children or those who have been born of their parents, the paramount consideration is the best interest of the child. Even if the child has reached the age of 18 and is inheriting when they're already 18 years of age, what happened to them between 0 and 18 should not be used to discriminate against them. That's all, and thank you very much.
Thank you very much as well. Yes, we'll definitely schedule one on family values. And thank you for even all your insights on second generation rights. We won't take much of your time. I just wanted to show you the audience that I'm with right now. So if the audience can gladly clap for Senior Counsel Charles Kanjama for his time, and a louder clap like that. There are some who have fallen asleep. So there we are. This is the first year group. They're energetic, and now they are definitely going to be constitutional law scholars. And then the other side, wow, look at them. A round of applause for Mwalimu Senior Counsel Charles Kanjama. Okay, so that's our little token from this side. Let me return the mic to Cedric Kadima to do the vote of thanks, give us announcements on the next event, thank our lead discussant for his time, his expertise. We've learned so much, and we can't wait to have another engagement in the near future. From it, thank you for the opportunity to serve as moderator and to be a student again back in 2015 at Strathmore Law School, learning. Now you even reminded me legal systems and methods and criminal law. It's been awesome. Kadima, if you can hear me, the floor is yours.
Yes, thank you very much, Melissa. And thank you very, very much, Senior Counsel Charles Kanjama, for that wonderful, wonderful discussion. I must say that this is one of the richest discussions we've ever had on socioeconomic rights, just tracing it back from the history till as recent as yesterday. And I think we'll use this recording for our future teaching and learning. So thank you very much, Senior Counsel. Again, I would like to express my sincere, heartfelt thank you to Senior Counsel. I think I hadn't mentioned at the beginning of the session that Senior Counsel had another engagement, but he specifically reserved time for the Avid Readers Forum and specifically for this discussion. We appreciate it very, very much. May God bless you for that kind gesture and sacrifice. I would like just to bring greetings from Professor Mbani, who is currently in South Africa, part of the participating faculty in the Christoph Haynes Moot Court competition. I'd also like to bring greetings from Mr. Ngoya, who would have spoken today, but just another slight engagement towards the end of this event, but he was with us. And to appreciate the audience also, which has followed us keenly throughout the session. I want to say thank you to you. I take this opportunity to welcome you in our next session, which will be next week on 9th of July. We'll be discussing the so-called third generation of rights. So please feel free to join us and follow through and ask questions and comment on the discussion. So thank you very much. My co-coordinator, Ruth Jebet, is also in the meeting. I would welcome her to close the meeting with a word of prayer and dismiss the crowd. I don't know if there's tea for the audience, both online and physical. I think Ruth will also tell us. Thank you.
Good evening. Thank you, Mr. Kadima, for this opportunity. Put me on the spot, but I'm glad to serve. So let us pray. Oh God, come before you today. Thank you for the almighty grace and favor that you've given us to be able to have such a deep and insightful event session with Senior Counsel Kanjama. It has not been because of our will, because of our strength, but because of the grace that you've shown us. We even pray for the sessions that are remaining, for the third generation rights and for the fourth generation rights, that you might be with us, may you cover us, we might be successful. And at the end of the day, all glory and honor will go back to you. Thank you for the feats that you have achieved, and we pray for each and everyone who has been able to attend today, that you might bless them and be with them. At the end of the day, all thanksgiving and glory will go back to you. Yes, I pray and believe. Amen. Thank you so much, everybody, for joining us. And yeah, we're going to resume our tea session when we come back physically, but I'm pretty sure you have earned a lot from today, and karibuni sana next week. Goodbye.